Yeah, I know.
Let me introduce you. Yeah, it's pretty interesting stuff and pretty interesting days. So we're happy to have as our speaker Marie Davis. Marie is an attorney with the Landegger Verano Law Group, who co-sponsors these webinars with us. She specializes in helping businesses navigate complex employment laws. And Marie is a member of the Ventura County Bar Association, the Consumer Attorneys Association of Los Angeles, and the Ventura County Hispanic Chamber of Commerce. She received her JD from the UC Hastings College of Law, and Marie is based out of Southern California. So again, folks, questions, we welcome them. Use the chat box on the webinar to ask those, and we'll get to that at the end of the meeting. Marie, what is sexual harassment?
If it was so easy to answer that question, then this would only be a 5-minute webinar, right, instead of an hour. And normally we do a 2-hour presentation just to give everybody who's listening an idea of how complex this is. And as Scott was mentioning just a few minutes ago, you know, I think a lot of people gave a lot of heat to the vice president a couple months ago. I'm not even sure if anybody even remembers that little scandal. It wasn't really a scandal, where he mentioned that he won't have dinner with a female unless it's his wife, and everybody kind of chuckled and scoffed at that. But again, maybe he's got the right idea, not because he's just uber in love with his wife, but because he wants to avoid some of these outrageous claims that have made themselves known in the last couple of months. So, harassment. Now, I'm going to be defining a lot of terms for everybody this hour, and just so you know, the reason why lawyers have jobs and judges have jobs and legislators have jobs is because we like to fight about what the definition of certain words are. So, what is harassment? Sexual harassment is really, it's like beauty. It's in the eye of the beholder. Or like one of our famous Supreme Court justices said about pornography, you know it when you see it, right? Well, again, you may know it when you see it, but if you are an ultra-sensitive person, you might consider a compliment a form of harassment because it's always in the eye of the beholder. Harassment of any kind, so this is, if you're feeling harassed, what are you going to be feeling? Harassment is bothersome, demeaning, irritating, and annoying behavior. Of course, those are all defined terms as well. Sexual harassment is specifically harassment of a sexual nature. And so it's harassment on the basis of sex. So currently under the law, federal law and state law, sexual harassment is what's illegal. The word, and I'm holding up my fingers and doing those finger quotes, harassment in the eye of the beholder is not illegal. There's been something, and we'll talk about it briefly at the end of today's session. There's been a law that's been trying to be passed called anti-bullying legislation. And the reason why, thankfully, it hasn't been passed yet is because bullying to one person could mean, somebody stole my lunch out of the office refrigerator, whereas real bullying may be your coworker telling you that you do a terrible job and you look awful and you're fat and nobody wants to hang out with you and you should just, be fired or you're never going to get that promotion. That would be real bullying, but because it's not defined appropriately, we don't want to legislate it. So sexual harassment is something that we actually can put in this particular box and define a little bit better so that we have a way of determining whether somebody is in fact guilty of sexual harassment or if somebody's just guilty of rude behavior. So most sexual harassment is simply disrespectful behavior towards others. The involved parties can, of course, be men or women. It can be same-sex sexual harassment, supervisors, subordinates, peers, or third parties. I mean, we've gotten claims here where the UPS driver is asking out the receptionist at a certain location, and what are we supposed to do with that? So sexual harassment can run the gamut. Obviously, sexual harassment in the workplace, as we've seen more recently as it's come out in the news with the Me Too movement, does in fact, the real form of sexual harassment can be devastating to a workplace. It can lower morale, it can lower productivity, and we definitely need to move towards eliminating it. So obviously the primary goal of this program is to help you identify what are those illegal behaviors and how we can move forward. So let's talk about the rules that govern it. Under federal law, Title VII, Civil Rights Act of 1964, it prohibits discrimination or harassment on the basis of race, color, religion, sex, or national origin. Notice, and I'll just go back, that's what's illegal under federal law. California law, federal law. 15 currently, but if you actually add up all of those hash marks and parentheses, you get about 45, I think. So under the Fair Employment and Housing Act in California, what's prohibited under discrimination and harassment are 15 different categories. So if you fire somebody, for example, and they make a claim, and they're saying that they were discriminated or harassed, if they fit into any one of these categories, and a lot of us fit into multiple of these categories, they have a basis for a claim. So you can see race, religious creed, color, physical or mental disability, pregnancy or related medical condition, sexual orientation, gender, gender identity, gender expression, age, denial of family and medical care leave. That's a whole nother webinar we'll be doing in a couple of months. So any of these 15 different categories can form the basis of a claim in California. So this is just a little, we have a couple of these throughout the presentation to kind of break it up a little bit, but you shouldn't let yourself get upset about Brad's behavior, Jenny, because boys will be boys. And then 2 months later, you shouldn't let yourself get upset about me calling the EEOC, Tony, because rules will be rules. And in fact, that is what happens. So what are the procedures for bringing a sexual harassment claim? You as a company need to make sure that you have internal complaint procedures in place. Once they've exhausted their internal complaint procedures, and sometimes they won't. I mean, sometimes an employee will simply just say, I don't want to talk to my supervisor about this, or perhaps it's the supervisor that in fact is the one that's doing the harassing conduct, so they'll just go right outside. The next level is the EEOC or the Department of Fair Employment and Housing. The EEOC is federal. The Department of Fair Employment and Housing is what governs California claims. And of course, the third step, which is the worst for you as employers, is civil litigation. Now, as I mentioned, an employee doesn't have to utilize the internal complaint procedures. That is not a requirement. In order to file a civil lawsuit, however, the employee does have to file an administrative charge with either the EEOC or the DFEH. Now, sometimes those independent departments will conduct their own investigation, and sometimes they even offer up private mediation to resolve the conflict. But most of the time, what happens is the individual will find an attorney. The attorney knows that they have to file a charge with the EEOC or the DFEH, so they'll just walk in and say, I'm filing this charge, but I want an immediate right to sue letter. The right to sue letter gets issued, and then they can just go ahead and file the lawsuit. So, timing of a sexual harassment claim from start to finish. So if we just came off of my favorite time of the year, Christmas and holiday parties, where one thing leads to another and accidents happen and words get misspoken and people get a little too touchy-feely. And I get phone calls on Sunday morning all December long. Anyhow, what is the timing? So let's say that December 15th, 2017 was the day you had your holiday party, and your supervisor got a little handsy during the picture taking with his secretary or a couple of file clerks. So he did something completely inappropriate and touched them, on the behind, or rubbed their shoulders or stroked their neck or something of that nature. So that happens December 15th. I'm sorry, that should say 2018. I'm sorry for my pause. It could take the employee until August 24th, 2018 to file the administrative charge with the EEOC or the DFEH, because she has 1 year to file the claim. So she could actually wait all the way until next December. But, you know, let's say it took her a while to feel bad about it. Maybe she comes to HR and complains about it, and she's not happy with the way it was resolved. So she waits and bides her time. Let's say she figures, it wasn't such a big deal. I didn't really care. It didn't really make me upset. But somewhere between December and August, you fire her or you lay her off for other reasons. Well, guess what? She could say, oh, yeah, I remember what happened, 9 months ago, and I still have time to file this charge. So it could take 8 months for her to file the charge. The conclusion of that proceeding is a year after that. So you have a year to file the claim, and then the department, the EEOC or the DFEH, has a whole nother year before they issue a right to sue letter. And then guess what? You have another year once the department has concluded its proceeding and issued the right to sue letter. You have a whole nother year after that before you have to file a lawsuit. And once you file the lawsuit, there's a 5-year rule that it has to be litigated. But let's say it gets filed 2 years later, so we're close to 3 years from when the incident actually happened. The first deposition will take another 6 to 7 months after that. So now you're 3.5 years after it happened. And how are you going to remember anything that happened 3.5 years earlier? Well, there's one way. Document, document, document. Because 3.5 years, a whole heck of a lot is going to change with your company. People are going to leave. Memories are going to fade because, heck, I don't even remember a conversation that I had with somebody 6 months ago. So when a situation arises that even you think might possibly hint at being inappropriate or causing some discomfort between your employees, it's real important to address it early. And again, that timeline that I just showed you is very real. I mean, I'm in the middle of a case right now that was filed back in 2014, and it involves stuff that happened in 2013 and 2014, and here we are 4 or 5 years later. So when the complaint first occurs or when the incident first occurs and you pick up the phone and you call your lawyer or you call your HR rep or consultant group, you want to make sure you write everything down because you will forget. So what happened? When did it happen? What did the complainant say? Just the facts, man, basically. And then we can guide you, and we'll talk about that more later, about what you do to complete your investigation. And even if you have to put it away and wait the 2.5 years before the lawsuit gets filed, at least you'll have something to fall back on if and when we need it. So just some statistics from 2 years ago. There were 6,822 sexual harassment charges filed with the EEOC. 17% were filed by men. 52% roughly were found to have no reasonable cause by the EEOC, but that doesn't mean that they weren't allowed to go ahead and file civil lawsuits because the EEOC can't tell them, well, we didn't find any validity to your claim, so therefore case closed. You still have a right in this country to file a lawsuit, and that's generally what happens. Only 6%, that's it, were found to have reasonable or probable cause out of 7,000 charges that were filed, which led to 7,000 separate investigations and many, 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 many hours and time and frustration on the part of the employer. $46 million in monetary awards issued by the EEOC. And these are just a couple of important decisions. This is a little bit of an old case, but it's just to give you an example. There was a $2.3 million verdict in just damages. The punitive damages on that claim were in excess of $50 million. Lyle versus Warner Brothers created an affirmative defense for sexual harassment. And what that was creative necessity. It's basically, I have a great example. I was working in an employment law firm. So we work in an employment law firm. Guess whose holiday party you absolutely do want to come to? Ours. Because we have a little bit of a looser rule around here because we are litigating claims such as this all the time. And that means that we don't have blocks on our For example, we don't have blocks on our internet because a lot of times we have to search things out when we are investigating claims of plaintiffs. So we have to tell all of our employees when they sign on that, look, when you're in this office, you may inadvertently be exposed to inappropriate content, either online or in messages or emails. And so we give them that warning, but they at least understand that because we work in a particular environment, they will be exposed to perhaps potentially inappropriate content. Well, in this case, same thing. A woman claimed that she was being sexually harassed because she was being subjected to the writers' banter in the writing room, where they would, say really crude jokes, use really bad language, parse out really crazy scenarios, but they were writers and they needed to do that because that's part of the creative process. So if you have, an environment, a work environment that legitimately may be not what you would expect in a traditional office setting, you have a defense there. But it's just like I just mentioned, you want to make sure that you disclose that to all of your applicants and that your employees understand what they're getting themselves into. And then this case was just to third-party liability, that you really are responsible for protecting your employees from those third-party outside vendors, your clients, your insurance agents, anybody who comes into contact with your employees. We're just going to go through some of this because I'm talking a little bit fast, but just so you can understand here, we've got $3 million verdicts, we've got $18 million verdicts. The Vaughn's verdict actually, I think, was $100 million in punitive damages. And all the other women in the office are suing you for sexual harassment, but since you haven't sexually harassed me, I'm suing you for discrimination. It's kind of funny, but also true. We've definitely had claims made where employees say that they're being discriminated against because 10 or 12 other receptionists in the office go to lunch every day and they don't invite her or whatever, so that's discrimination. It's not illegal what your employees do on their off time, but we definitely do get claims like this, so you have to be careful. All right, so what is the EEOC definition of sexual harassment? Unwelcome sexual advances or requests for sexual favors and other physical or verbal conduct, which, and this is why the green is what's really important here, which explicitly or implicitly affects an individual's employment surroundings. Unwelcome, and which has a negative effect on the employee's, ability to perform work. So, of course, the victim as well as the harasser may be a woman or a man. The victim does not have to be of the opposite sex. The harasser can, of course, be the victim's supervisor, an agent, a supervisor in another area, a coworker, or a non-employee. Now, we'll talk about this more in a minute, but and what we've heard in the news lately is that when it is a supervisor or a boss, when you have somebody who has power over the woman, or, and sorry, I'm using the fallback to women because the majority are women, but if the alleged harasser has power over the victim, it is much more difficult to lodge a defense against that type of claim. And in fact, in California, we have something called strict liability. Strict liability means that if a supervisor is accused and found to have sexually harassed a subordinate, there are no defenses. Under California law, strict liability means supervisor did it, therefore you are wrong and you have to pay the plaintiff damages. So it's very, very important to go through with that supervisor sexual harassment training every 2 years. And of course, unlawful sexual harassment can still be illegal, even without, quote, economic injury to the victim or discharge. I mean, the fact that you are working in an environment, a hostile, sexually hostile, severe and pervasive work environment, that's still enough to get emotional distress damages, and it's still enough to get punitive damages. Okay, so there's also two forms of sexual harassment. So we know that the legal, quote, legal definition is unwelcome sexual contact that affects the environment, working environment of the victim. Those are the three things. Now there's two different types. Quid pro quo is what we all generally think of when we think of sexual harassment up until the last few months, right? It is, if you sleep with me, I'll give you a raise. Or if you don't sleep with me, I will fire you. That's quid pro quo. Sleep with me to either get a benefit or sleep with me so that you don't lose your job. Now, the other version is hostile environment. And that's what we are hearing about more recently now with the Me Too movement, and especially what's been happening in the entertainment industry. Hostile work environment occurs when an employee is subjected to unwelcome verbal or physical conduct of a sexual nature, which is sufficiently severe and pervasive so as to alter the terms and conditions of the employee's work environment. And it can also be caused by coworkers, supervisors, managers, or whoever. And the victim does not need to establish a tangible or economic job consequence. She simply needs to identify, I walked into his office and he was in his underwear. And again, we've just heard about that. And we've heard about a lot more severe things happening. And again, it doesn't matter that the individual may or may not have actually touched the employee. It's enough to create a sexual hostile work environment to walk into somebody in power, somebody who's always on television, and you walk into his office and he's either naked or in his underwear, and then he presses a button under the desk that locks the door. Well, yes, that's going to create a sexually charged hostile work environment. And you don't need to, the victim doesn't need to say, well, I was standing in there for 5 minutes and so I lost 5 minutes of my wages. Like, she doesn't need to prove an economic job consequence. It's just enough that she had to suffer that behavior, and it will clearly lead to high awards. And I'm sure we're going to see lots of payouts coming in the next several months for emotional distress and punitive damages. Now, for hostile work environment, there are two standards that we need to consider: the objective standard and the subjective standard. So thankfully, yes, we do have a thin line of reasonableness on our side as the employers and on the defense side of the fence. So the reasonable person standard is, would a reasonable person who is in the same age, race, job category, station in life, would a reasonable person in the victim's shoes believe that the conduct reaches the level of severe and pervasive sexual harassment? Now, thank you. That's good. I'm so glad that we have that. Once in a while, the law is on our side. But the other side of it is that we also have the subjective standard, which is like, does the victim actually believe that what she suffered constitutes sexual harassment, or did she just make it up because she was hoping that just by virtue of the fact that she had a sexual relationship with her boss, if she consented to it, then that's not sexual harassment because she didn't actually consider it to be sexual harassment. I'm trying to simplify it as much as possible. So what are some factors to consider? Well, the frequency of the conduct, obviously. The severity, which again, like when you walk into the room and your boss is in his underwear and he presses a button and the door locks, that's pretty severe and that's pretty obvious. So that's going to be a one-time, no questions asked, that's sexual harassment. Was the behavior physically threatening or humiliating, or was it just an offensive utterance? Or was it, I have a case on my desk right now, which I'm trying to figure out what to do with. And the allegations are simply that a waitress walked into the kitchen and the chef said that she looked good in her uniform. And it was the tone of his voice, apparently, that made her uncomfortable. So was it a compliment, or is it sexually harassing behavior? Does it really affect the employee's psychological well-being? And does it really unreasonably interfere with the employee's ability to perform his or her job? And of course, as we've gone over again, but conduct that constitutes sexual harassment can be verbal, it can be written or electronic. So if you get those email jokes, you want to be careful about what's circulated around your office. I had another, it wasn't sexual harassment, but it was race harassment and discrimination claim where a manager walked into the office and saw Post-it notes posted to the computer. And on each Post-it note was a stick figure. I mean, literally a stick figure. And there were 3 stick figures that just looked like stick figures, and they had different hair designs. And on top of the name of each of those stick figures were the names of 3 waitresses who all happened to be, skinny and blonde. And then there was a picture of this assistant manager, I should say. And his stick figure showed him as fat and Asian. And so that was enough, even though it seems kind of innocuous because it was just a stick figure. That was enough for him to still bring a claim of harassing conduct. And of course, visual is what I talked about. If somebody walks, if somebody is using the internet and not using it appropriately, and somebody walks in and sees inappropriate material. So some more examples, obviously, telling sexual stories or jokes, referring to other employees such as sweetie, doll, honey, or babe, making sexual comments or innuendos about a person's body or appearance, questioning a person about their sexual experience or preferences. I mean, this is, I think, pretty obvious to everybody, and hopefully now everyone's a little bit even more cautious. Written or electronic harassment, I just said that, sending the unwanted notes or messages. Text messages, please, everyone, if you only get one thing from me today, stop text messaging. Text messaging can really turn a case around. Let me tell you, do not believe for a second that your text messages are actually deleted. They're not. The other person has probably kept them, forwarded them, saved them to some file, and they will come out and they will hurt us. So I hate text messaging, but just, remember what you're doing when you're sending an email or you're sending a text message, because it can all come back to hurt you later. The other thing is that if you ever receive a text message or an email that you think is inappropriate or that contains a complaint or, anything that raises a red flag in your opinion, save it. So in fact, do what I always see happening on the other side. Save it, save it, save it. Don't delete it, because it could help turn the case around at the end. And of course, physical conduct, touching, stroking, massaging, kissing, invading someone's personal space. So no, I don't call it sexual harassment. I call it casual Friday. So that's a little joke to what we were just talking about a few minutes ago. In the eye of the beholder. So, well, this guy didn't think that it was sexually harassing to come to work in a Speedo. So he, but the reasonable person might. And then, this is another example of what would be considered sexual harassment. Go ahead and climb the, sexual harassment forms if you're going to file a complaint. Go ahead, they're on the top shelf. So, when we remember what's the definition of sexual harassment: unwelcome, sexual nature, and creates a hostile work environment. Welcome or unwelcome? Well, when meeting a person for the first time, holding a handshake a little longer than normal, is that welcome or unwelcome? Is it harassment, or is it perhaps a cultural difference between two people? Standing behind a coworker seated at their computer and putting your hand on his or her shoulder. I've done this once or twice in my career, and in the last year or so, I think I've been a little bit more cautious about it, because it's just something that you might naturally do if you've worked together for a while and you're leaning over them. You might just touch their shoulder, but you never know how that person is going to interpret it. Staring at somebody's body rather than looking at him or her in the eye while talking. looking someone up and down, making remarks about somebody's body, either in person or talking with somebody else, but, you know, somewhere where the individual who's being talked about can hear it. And so, of course, general guidelines. It's like golden rule, common sense, respect. Respect the people who are around you. Think before you act. Imagine how other people might feel or how you would feel in the same situation. I feel like I'm talking to you now like the same way that I talk to my 5-year-old. Think twice before making a joke, any joke. And unfortunately, just based on the times that we live in, and things are changing even more and more rapidly, you really, really, really have to be cautious about what you say or do, because there are some overly sensitive people, and there are also people who are out to look for an easy buck. And so even if you honestly are just making some sort of just completely innocent joke, it could come back to hurt you, especially if you're in a supervisory position. I mean, it's just the sign of the times. And, you know, this is the world that we live in, and so you got to think twice. The questions to ask yourself, and I like these. Would my spouse, parent, child, or sibling like to be treated this way? Would I like my behavior published in the organization's newsletter? Could my behavior offend or hurt other members of the work group? And could someone misinterpret my behavior as intentionally harmful or harassing? The answer to that last question is yes, absolutely. There will be someone who can, even if it's not true, say that they misinterpreted your behavior as intentionally harmful or harassing. If you just, you know, that's my whole point. If you bring up a joke, or if you bring up a statement that involves the word sex or a body part or a race or a religion, or, you know, anything in that nature, you are asking for trouble. Is the behavior directed only toward women or men? Can the behavior be classified as flirting? Does the behavior make it more difficult for the employee to do his or her job? Has the employee received the attention, objected to the behavior in any way? And I get this, and I know somebody out there has probably already typed this as a question. What about inter-office relationships and romance? Well, clearly it happens all the time, because we spend so much time at work that obviously a lot of us have met our spouses in the workplace. That's kind of just the way it is. So what do you do when it's two consenting adults that have fallen in love? Well, if they're coworkers, you have to let them have their privacy. If it becomes an issue at work, such that they're making out at the desk in the cubicle in front of everybody, then you're allowed to step in, clearly, because that's inappropriate work behavior. Keep that at home. If it's between a supervisor and a subordinate, however, you got to do something. You got to step in. And this is because even if they're madly in love and they even get married, let's say they get married and they have 4 kids, the day that one of the spouses who wants to get a divorce is the one that was on the subordinate side, he or she will claim, I was forced into the marriage, I was forced to have the 4 kids, and it's all because I wanted to keep my job. And I'm serious, there have been claims like this. I promise you, I'm not just making it up. So if it's between a supervisor and a subordinate, you have to separate them. They have to be in different departments. The supervisor cannot have any type of control over the subordinate any longer. Intent versus impact, and I've sort of explained this a little bit as we've gone along. Intent is not relevant in determining whether or not behavior is sexual harassment. All that matters is the impact on the work environment and in the eyes of the victim. And I'm sorry, I skipped ahead a little bit. While office romances are not illegal, they can create serious problems. So agents, supervisors, I've said you get the strict liability. That means there's no defenses whatsoever. If he was the supervisor and she was the subordinate and she claimed sexual harassment and something occurred, then that's it. That's all, you're done. A supervisor is somebody who, this is important too. What is a supervisor? A supervisor is somebody who has control to hire, transfer, suspend, lay off, promote, discharge, assign job responsibilities, reward, or discipline. That's the definition of supervisor. Third party, we already, again, went over this. An employer is liable if it knew or should have known of the harassment by the UPS officer. By the UPS delivery truck or, driver. You are responsible if you knew or should have known of the harassment and failed to take any steps to stop it. Now, so now that everybody's probably, kind of bummed out, there are, in fact, some affirmative defenses to harassment. There's a few. Under Title VII, an employer may avoid liability by proving that it exercised reasonable care to prevent and promptly correct any of the alleged behavior, because if it didn't come from a supervisor, what we like to say is you get the one-shot rule, basically. If a coworker, asks another coworker out, if a coworker is the one that wrote some sort of letter to the other coworker or posted the Post-it note that happened to show the coworker with large breasts, that is clearly going to be sexually harassing behavior that needs to be investigated and dealt with. But so long as you actually took reasonable steps to correct and prevent it, then you will face little or smaller, perhaps even no liability on that charge. But again, if it comes from a supervisor, it's strict liability. And in California, what that's called is the avoidable consequences doctrine. But again, it's employer took reasonable steps to prevent and correct. Employee unreasonably failed to use those corrective and preventative steps. And again, it reduces the employer's liability for damages. So, role of the supervisor, most of you listening, I understand, are going to be in either the HR department or management department. So what can we do to prevent? Well, first, communicate. You want to make sure that you have a very clear anti-discrimination and anti-harassment policy. It's got to be in your handbook. It's got to be posted in the break room. We actually have one, and I'm happy to share it with anybody who's listening. I can send you a very compliant policy, and it even has a line for employee acknowledgement with a date, so that they understand that this company does not tolerate sexual harassment of any kind, well, harassment or discrimination of any kind, gives examples of what sexual harassment is, describes and outlines a complaint procedure and policy, and states that the company will, in fact, investigate all complaints, and that the company will not retaliate against anyone for bringing a complaint. Recognize the early signs of, uh-oh, I don't like where this is going, and stop it. So stop or interrupt any inappropriate behavior, enforce dress codes, don't encourage inappropriate behavior, clearly manage your employees in a job-related manner, write them up, verbal warnings, written warnings. And then if you actually do get a complaint, and this is what's super important, because again, when somebody complains about what occurred at the December 15th, 2017 holiday party, I want to know everything way before, way before Christmas. I want you to be able to at least take the first steps of this investigation, because 3 years later, you're just not going to remember. So be prompt, be serious, be sensitive, be objective, and do your best to be confidential. Try to get an agreement with the victim and the accused on what their stories are. Conduct interviews of the victim and the witnesses, write down the facts, ask them to sign the statement, have the victim put his or her complaint in his or her own words in writing, and always ask the victim what would he or she like to see happen. Once in a while, I know this might be surprising, once in a while it's more, all they want is an apology. Or it might move up to the next level of, I don't want to work, the same shifts as this guy, or I don't want to share the same cubicle with this guy anymore. There's, if that's the case, there's simple resolutions to that. And certainly you have to interview the alleged harasser as well as the alleged victim. And you want to advise the complaining party of the results of the investigation. What constitutes disciplinary action? I'm sure everybody knows that there's verbal warnings, written warnings, unpaid leaves, additional training, retraining or reemploying a probationary period, reassignment and demotion, transfer, and then ultimately, depending on the severity of the behavior and the employee's history, then certainly termination is also an option. So, as I said, at the end, we were going to talk about bullying, only because I wanted you to see the difference. I mean, sexual harassment can, in fact, be defined. I mean, even though we argue about what is it, and we at least can boil it down to unwanted sexual nature has a negative impact on the work environment, and we can define it we can litigate it in terms of the reasonable person standard. Unfortunately, anti-bullying is not that clear, and again, thankfully, it is still not, quote, illegal. It hasn't been written into any of our state's laws. So you will never receive, at this point, you're never going to receive a complaint that says, I was bullied. And, again, the definition of bullying, it just needs to be tightened up, and you'll see why. So bullying is unwelcome. Okay, we get that. Or, quote, unreasonable. What is the definition of unreasonable? Behavior that demeans, intimidates, or humiliates people, either as individuals or groups. Unfortunately, there's no definition for demeans, intimidates, or humiliates people because it's always in the eye of the beholder. So, some examples of bullying behavior, according to the people that are trying to get these laws instituted: abusive and offensive language, insults. But again, what's an insult? Because telling somebody what's an insult? It could be, I don't like tuna fish sandwiches, right? So if I see my coworker eating a tuna fish sandwich and I say, oh God, that smells awful, is that an insult? Is that bullying? Probably not. But if the person who's eating the tuna fish sandwich considers it an insult, then I might have a complaint on my desk for being a bully. So I do really believe that this goes a bit too far. But insults, teasing, spreading rumor and innuendo, what the heck is that again? Unreasonable criticism. Believe me, how many of you listening have employees who think it's unreasonable when you tell them, I need this report done by Friday? You tell them on Monday that you need the report done by Friday, and if they don't have it done by Friday, then you go to them and say, why the heck don't you have that report done? You're not doing the job that I need done. You know that there are employees out there that are going to think, oh, well, that's just unreasonable criticism. I can't say this word, trivializing work achievements. So same thing. If I am an employee that I say, it's Monday afternoon and I need this report by Friday, and she gets it to me by Wednesday, I'm probably going to say, hey, great, thanks. What if she expected me to give her a raise because she got it done 2 days early? Again, what's going to be the definition of trivializing work achievement? This is my favorite. Manipulating the work environment. Okay. Excessive demand, setting impossible deadlines. Again, who's going to, is 5 days an impossible deadline? I guarantee everybody listening has an employee who thinks that 5 days would be a, quote, impossible deadline. And excessive demands, such as, showing up to work on time. Psychological manipulation, like unfairly blaming somebody for mistakes, setting people up for failure, deliberate exclusion, excessive supervision, practical jokes, belittling or disregarding opinions or suggestions, and criticizing in public. Probably out of all of this, the only thing would be criticizing in public, or belittling an opinion or suggestion. But, I've seen so many cases where employees are just, they think that they've got the greatest ideas in the world, and if their boss doesn't employ their ideas, then the boss is belittling or disregarding or, criticizing them unfairly. So, again, thankfully, anti-bullying, it's not in law because we really have to deal with what some of these definitions could possibly mean. Mobbing is a particular type of bullying behavior carried out by a group rather than an individual. Mobbing is the bullying or social isolation of a person through collective unjustified accusations, humiliation, or emotional abuse. Now, this is easier to recognize. If you find out or you have an employee that comes to you and is complaining that the 13 other receptionists always go to lunch together, they never invite her, and they make a big scene when they leave, like, oh, hey, we're leaving, sorry, Sally, you know, you have to stay because somebody has to answer the phones and we don't want you and you're not welcome here. If you see that, because that's very clearly something you can identify, then you need to address it. And of course, you need to address anyone who has a complaint of any kind. But I'm just saying, I don't want anybody having anti-bullying, quote, anti-bullying policies in your handbook or posted in your break room, because it's just asking for trouble and disaster. Now, the responsibilities, again, it's not legislated, but managers and supervisors, just as I just said, respond promptly, sensitively, and confidentially to all complaints that are brought to your attention, but you don't necessarily have to handle it in the same way as real complaints of harassment. I want to report my boss for harassment. He's created an environment that I find offensive and hostile. Why? What happens? Well, he keeps giving me work to do, and that's exactly what I know all of you have heard, and what I've heard and seen come across my desk time and time again. So what have you learned? I'm going to go through this quick so that we can, I'm only going to do actually question one, so that we have a few minutes for questions, because I know I'm trying to do a 2-hour presentation in 1 hour. But while at work, Janet frequently makes personal phone calls to her friends. Her conversations are loud and generally sprinkled with sexual explicit language. Her coworkers cannot help but overhear her conversation. True or false? Janet's behavior cannot be interpreted as sexual harassment because she is not addressing her language directly towards her coworkers. So again, I'm not here to see everybody raise their hands, but hopefully, because you have all been paying attention, the answer to that is false, because in fact they are hearing, if the coworker can hear her sexually charged conversations, then she can be in trouble for harassment. Okay. Question number 2, and then Tony persists in asking his coworker Mary out to dinner, even though she turns him down each and every time he requests a date. She has told him several times to stop asking. True or false? Tony's behavior is not at risk for sexual harassment because sexual harassment may only occur between a boss and a subordinate. Well, you all know that that is also false. It can occur between coworkers, third parties, clients, vendors, anyone. So, Scott, I know these are great questions, and they'll be posted to the website, and I'm sure